Navigating the aftermath of a security incident requires more than just technical skill. It necessitates a deep understanding of the legal boundaries that govern digital evidence and actor behavior. We are surveying the landscape of computer crime laws that dictate how you must handle digital investigations to ensure that your findings are both lawful and admissible. Typically, a response team that operates without regard for these statutes risks not only the failure of a prosecution, but also potential civil or criminal liability for the organization itself. In practice, the legal environment acts as a set of rules for the digital road, defining where an investigator can go and what actions are considered out of bounds. What this means is that every technical step taken during an incident response must be measured against the prevailing laws of the jurisdiction in which the activity occurs. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyber.author.me in the Bare Metal Study Guide series. A foundational piece of legislation in this field is the Computer Fraud and Abuse Act, CFAA, which serves as the primary federal statute in the United States for prosecuting unauthorized access to computer systems. This law outlaws conduct that victimizes protected computers, a term that has expanded over time to include almost any device connected to the Internet. Typically, the CFAA prohibits intentionally accessing a computer without authorization or exceeding the level of access one has been granted to obtain information or cause damage. In practice, you will often see this law applied to cases of external hacking, the distribution of malicious code, and even certain instances of insider threats involving data theft. Understanding the nuances of this act is essential for identifying when a security breach has crossed the line into a federal criminal offense. You can improve your professional readiness by identifying the specific activities in your current jurisdiction that would be considered a federal crime under the prevailing computer laws today. This might include the unauthorized interception of electronic communications, the trafficking of stolen passwords, or the intentional disruption of a government or financial system. Typically, these crimes carry significant penalties, including heavy fines and lengthy terms of imprisonment, depending on the severity of the damage caused. In practice, knowing the elements of these crimes allows your team to better document the evidence needed by law enforcement to build a successful case. What this means is that your internal investigation is not just a technical exercise, but a gathering of facts for a potential criminal referral. A frequent and highly dangerous pitfall during a crisis is the tendency to conduct an internal investigation in a way that accidentally violates a suspect's fundamental privacy rights. In many jurisdictions, individuals have a reasonable expectation of privacy that protects their personal files and communications, even when they are using corporate resources. In practice, if an investigator searches a personal folder or reads a private message without a clear legal basis, the entire investigation could be compromised. Typically, evidence gathered through an illegal search is deemed poisoned and will be excluded from any subsequent legal or disciplinary proceedings. This realization highlights why a disciplined and legally informed approach to evidence gathering is just as important as the technical tools being used. You can achieve a significant quick win for your investigative protocols by reviewing your current employee handbook for specific language regarding the expectation of privacy in the workplace. Most mature organizations include a clear policy stating that employees should have no expectation of privacy when using company-issued devices, email systems, or network infrastructure. In practice, this language serves as a form of implied consent, providing the organization with the legal authority to monitor and search its own assets. Typically, if this language is missing or unclear, the burden of proof shifts back to the employer to justify why a search was necessary and reasonable. What this means is that your policy manual is a critical legal tool that provides the right to monitor needed for a defensible investigation. It is helpful to visualize a comprehensive legal framework that balances the inherent privacy rights of the individual with the legitimate security and business interests of the modern corporation. This balance is not static. It is constantly being refined by new court decisions and legislative updates that respond to evolving technologies like cloud storage and remote work tools. Typically, the court will look at whether the organization's search was justified at its inception and whether it was reasonably related in scope to the circumstances of the incident. In practice, a well-balanced framework allows the company to protect its intellectual property and systems while respecting the dignity and rights of its employees. This visualization helps you see the law not as a barrier, but as a guide for conducting fair and professional investigations. In the world of United States federal law, practitioners frequently use the term CFAA, Computer Fraud and Abuse Act, to refer to the primary legal instrument used to prosecute computer-based crimes. While the act was originally designed to protect government and financial computers, it now covers any computer used in interstate or foreign commerce, which effectively includes every smartphone and laptop. Typically, a CFAA violation requires proof of unauthorized access or exceeding authorized access, a distinction that has been the subject of several landmark Supreme Court rulings. In practice, this means that simply violating a company's acceptable use policy might not be enough to trigger a criminal charge under this specific act. Understanding these legal nuances is critical for correctly classifying a security incident and determining the appropriate level of response. Reviewing influential global laws and treaties, such as the Convention on Cybercrime, often known as the Budapest Convention, helps you understand how international digital evidence and cross-border investigations are handled. This convention serves as the most comprehensive international treaty seeking to harmonize national laws and improve investigative techniques among signatory nations. Typically, it provides a framework for international cooperation, allowing law enforcement in one country to request the preservation or collection of evidence held in another. In practice, this is essential for responding to threats that originate from foreign jurisdictions or involve data stored in multinational cloud environments. What this means is that your investigation may often require a bilingual understanding of both domestic laws and international treaties to be effective. Imagine a challenging and high-pressure scenario where a former employee sues your organization for invasion of privacy after you looked at their personal messages during a fraud investigation. If the investigation was not conducted according to a clear and pre-existing policy, the company could be found liable for significant damages even if the employee was guilty of the fraud. Typically, these lawsuits focus on whether the investigator stayed within the scope of their authorization or if they overreached into purely personal territory. In practice, the cost of defending such a claim can often exceed the value of the original fraud that was being investigated in the first place. This scenario highlights why the legal foundations of your investigation are a non-negotiable part of your organizational risk management and professional defense. Every professional should anchor their investigation strategy in the fundamental legal principle that you must have a clear and demonstrable legal right to monitor and search any system or data source. This right can come from a signed employee agreement, a specific clause in the employee handbook, or a compelling business necessity that outweighs the individual's privacy interest. In practice, before any search begins, the response team should verify that the target device or account is within the scope of the organization's monitoring authority. Typically, a no-surprises approach where employees are clearly notified of the company's monitoring practices is the best way to maintain a defensible and professional environment. What this means is that your authority to investigate is granted by the rules you establish before an incident ever occurs. We have now outlined the major federal and international statutes that define cybercrime and establish the legal boundaries of a lawful corporate investigation. By understanding the rules of the road, your response team can gather evidence with the confidence that it will stand up to the intense scrutiny of a courtroom. Typically, the most effective investigations are those that are designed from the beginning to be legally robust and technically accurate. In practice, this means that the technologist and the legal counsel must work in total harmony to ensure that every search is justified and every action is documented. This integrated perspective is what differentiates a high-performing incident response team from one that is merely reactive and legally vulnerable. A highly effective practice is to involve qualified legal counsel very early in any significant investigation to ensure that your search methods and evidence collection will not be successfully challenged later. Legal experts can provide a sanity check on your investigative plan, helping you navigate complex issues like attorney-client privilege and the legal requirements for a search warrant. In practice, having a lawyer review your steps provides a layer of professional protection and ensures that the organization's actions are fully supported by current case law. Typically, this collaboration results in a much more defensible report of investigation that can be used with total confidence in disciplinary hearings or criminal trials. What this means is that you are using legal expertise to bolster the validity and the impact of your technical findings. Knowing these computer crime laws and privacy regulations ensures that your internal response team stays on the right side of the legal line during a high-stakes investigation. When the rules are understood and followed, the focus remains on uncovering the facts of the incident rather than defending the methods used to find them. Typically, a team that is known for its professional and lawful conduct is more likely to be trusted by management, law enforcement, and the judicial system. In practice, the energy you spend on mastering the legal survey today is a direct investment in the long-term credibility and success of your security and response operations. This focus on the law is what ensures that your organization remains a respected and legally sound participant in the global digital economy. This legal survey of computer crime and investigation laws is now complete, and you have gained a solid understanding of the primary statutes and principles that govern your professional work. We have discussed the role of the CFAA, Computer Fraud and Abuse Act, the importance of the expectation of privacy, and the necessity of maintaining a clear legal right to monitor systems. A warm and very practical next step for your own professional growth is to take a moment today and look up a summary of the latest CFAA rulings and interpretations online. As you read, consider how these laws apply to the specific technical systems and employee behaviors you manage in your daily role. Moving forward with this deep legal awareness will help you ensure that your investigations are always safe, legal, and fully defensible.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit BareMetalCyber.com.